Alternatives to Guardianship and the Promise of Supported Decision-Making. The American Civil Liberties Union and the Center for Excellence for Developmental Disabilities at the University of California, Davis, Mind Institute, have created this series of videos to help individuals with disabilities, families, advocates, lawyers, and doctors understand some of the dangers of guardianship and conservatorship and the potential promise of supported decision-making. In the first video, Jonathan Martinez, Senior Director for Law and Policy at the Burton Blatt Institute of Syracuse University, introduced us to supported decision-making and the connection between our choices and our civil liberties. This second video outlines 5 of the top concerns about guardianship and conservatorships. Part 2. 5 reasons to rethink guardianship. An introduction to guardianship and conservatorship. Guardianship or conservatorship is a legal process where a court takes away the rights of a person with a disability to make decisions and gives those rights to another person. Most states use the term guardianship for this process, but some states call it conservatorship. In these videos, we will use the terms guardianship and conservatorship interchangeably. The people who are most likely to be put under guardianship are people with intellectual or developmental disabilities, people with certain psychiatric disabilities, and people with dementia. In these videos, we will focus primarily on the problems of guardianship for younger people. The guardianship process begins with a petition to a court where someone, often a parent, asks the court to appoint a guardian for a person. The judge will impose the guardianship if she or he finds that the person is incapable of making decisions. Only a judge can grant, change, or end guardianship.
Because guardianship is the extraordinary process of removing a person's rights and giving the guardian binding authority over the person's life, there must be strong safeguards within the process. In practice, the safeguards that are currently in place are rarely enforced. Guardianship should be a last resort. In reality, many states and many judges impose guardianship as a matter of course, essentially as a first resort. There is often no real consideration of whether less restrictive alternatives might be appropriate. Most state laws say that guardianship should only be imposed when there are no less restrictive alternatives available. Even the National Guardianship Association has a position statement that reads, "Guardianship should be utilized only when lesser restrictive supports are not available. Alternatives to guardianship, including supported decision-making, should always be identified and considered whenever possible prior to the commencement of the guardianship proceedings." In practice, few people who have gone through the guardianship proceedings report that there was any discussion or exploration of less restrictive alternatives.
The reason I got the conservatorship was that the school administrators told me that it was necessary, that if I didn't, that my son would be alone at the IEP meetings and would have to negotiate services on his own. So I went to an attorney who was experienced at providing conservatorships, and she didn't provide any suggestions of alternatives, and nor did the school. So I was unaware of any alternatives to conservatorship.
When a guardianship is appropriate, it should be limited only to the specific areas in which an individual is incapable of making decisions. It should be as limited in scope as possible. In practice, however, judges almost always order full or plenary guardianships, taking away all of a person's choices. Many families initially see plenary conservatorship as a safeguard only to be acted on as a protection against an unexpected situation. Many families may be very encouraging with their loved ones to make many choices that are technically covered by the guardianship. This can have serious unexpected implications if a new guardian takes over who does not know or respect the needs and legitimate desires of the person they have decision-making power over. When this happens, the person who is conserved and their families have very little recourse.
Sometimes parents go to court in order to have conservatorship only for 1 or 2 areas of decision-making. But once you've entered that realm of the court, the judge is the one who has then taken on the responsibility of deciding what the adult with a disability needs help with.
Guardianship gives power to the court, not the family. Many families initiate guardianship believing that they need the guardianship in order to continue to be able to support and guide their loved one who has a disability after they become a legal adult. families believe that they will be able to always ensure that the guardian will be a family member who loves and is very involved in the person's life.
So I thought that conservatorship would be a continuation of parental rights, that I'd be able to protect my son by getting a conservatorship. But it turned out I was wrong. It turns out that conservatorship does not give parental rights to the conservator. It gives the rights to the court. So it takes the rights away from the conservatee, gives those rights to the court, and the court orders the conservator to do what the court wants.
One thing we see a lot is when both parents come to court and let's say they're divorced and each parent tells the court, I want to be the guardian for my son or daughter with a disability. And the parents can't decide which of the two parents should be the guardian. Sometimes the court will say, okay, well, I'm going to appoint this third party to be the guardian. And so it's then not either parent, it's actually a stranger to either parent, and it's a stranger to the person with the disability. And parents can sometimes be surprised by those kinds of decisions by the court.
Once a guardianship is in place, the judge can replace the guardian with another person at any time. The new guardian may be someone the person with a disability has never met. The guardian can make decisions that control the life of a person that they have very little information about, and they can make those decisions without the input of the person or their family.
After 3 years of being conservator, I resigned as the conservator that's all I could do. There was really no choice. And then when I resigned, the court appointed a professional conservator. The new professional conservator company, they're located an hour and a half away from Los Angeles and from his apartment. And so that makes it very difficult for them to respond to an emergency. And it also means that they can't visit very often. And I don't think that the new company has the time to come that far to get to know him and spend time talking with him.
I have patients who have court-appointed conservators who've never met the person that they're supporting, who don't show up when the person is in the hospital. Sometimes conservators who know very little about the situation will sign off on informed consent, even without understanding the person's priorities and even without having very much of a relationship with them. Other times when conservators can't be reached or are reluctant to make a decision, people go without care because you can't get informed consent and it isn't an emergency. It can delay care in ways that are very harmful.
Although it can be quite easy to get into a guardianship, it's very difficult to get guardianships ended. By definition, a person under guardianship has been deemed to be unable to make decisions for themselves, so judges are reluctant to find that person has become competent, even when the family supports ending the guardianship. In situations where the courts have named a non-family member as guardian, families have very limited influence to end the guardianship. This can be tragic in situations where people with disabilities and their families find that guardianship has unexpected negative consequences and then find they are unable to end the process. The process of trying to terminate guardianship requires money, hiring a lawyer, obtaining numerous evaluations and reports, attending court hearings, and it requires a judge who is willing to end the guardianship, which seldom happens.
I've represented approximately 150 people over a 10-year period in limited conservatorships. And during that period of time, I've represented probably 5 individuals where there was an issue about whether or not the conservatorship was terminated. A lot more people get into conservatorships than get out of conservatorships, but it's also more difficult to challenge the conservatorship later on because the burden shifts to the conservatee to produce all of the evidence to get off of conservatorship.
So some people have suggested that we consider eliminating the conservatorship, given how much he's grown. And when I've asked about that, the attorneys pretty much tell me that it's an irreversible process or just extremely difficult to undo.
Guardianship views capacity as an on-off switch. It isn't. Many families have developed a process of supporting their loved ones by helping them understand complex situations and help guiding them through the options.
We think about capacity as you have it or you don't, on-off switch. But in fact, most people have a spectrum of capacity. And for some things, They may be able to make decisions entirely by themselves. For some things, they may not be able to make the decision, but most things, people can make decisions as long as they have some good advice, a little bit of support, a little bit more information, things explained to them in terms they understand.
Some people have little or no verbal communication, but can indicate their preferences by nonverbal cues or how they react to different options and situations. People who know the person well can often use these cues or past history to help communicate their desires, preferences, and strong dislikes. Other people may be able to communicate either through speech or communications devices when they're calm and in familiar environment, but be totally unable to communicate through these methods when they're feeling anxious or in unfamiliar environments.
I believe wholeheartedly that everyone can communicate, and if you just take the time to learn how each individual communicate, they can tell you, this is how I want my medical decision to be. I'm not blaming doctors. Well, yes and no. But I think doctors need to take a step back and realize people with disabilities are people, and they need to understand that we are capable of making choices. And I don't think we need a conservator telling us how our life should be.
Sometimes people can make certain types of decisions, but not others. Sometimes people can make a decision when they're calm, but not when they're upset or agitated. Or sometimes people can make decisions when they are feeling well, but have more struggles when they're feeling poorly. That's true of all of us, right?
So someone might have the capacity to make certain decisions very well, such as where they live, who they want to spend time with, and they may have less capacity in other areas. So for example, with financial decisions, someone might need more supports in that area. So really, capacity varies, but that's not how courts look at it.
Guardianship looks at one snapshot of a person's life.
So one of the problems with guardianship and conservatorship is that young people with developmental disabilities often have that guardianship or conservatorship imposed when they turn 18. And if we know anything about kids with developmental disabilities, we know that they develop differently. It's not that they don't develop.
When I first moved out of my foster mom's house and I heard about supported living and that this agency was the one that could take me on, and they fed me a really good story about, oh, we'll do this and we'll have emergency pagers, so if anything happens, you can call and you would never be alone, and don't worry. What was so bad about it was they totally lied to me because they didn't have the emergency pager set up like they said they were going to. And when my roommate at the time had twisted her ankle and she was walking on crutches and she couldn't put me in the bed at night, I ended up having to stay in my chair the whole entire day from the whole entire night. The important lesson to that is looking back on it. I would now, I don't accept the first thing people give me. I do a lot of asking a lot of questions before I just say, okay, well, that sounds great.
So my son's now 29, and in the last several years, he's continued to grow amazingly. He's learned how to make many of his own decisions. He's learned to communicate much better, to express what his decisions are, and to show consistency in those decisions. I'm very pleased he's now got 3 part-time jobs. He's been living in his own apartment. He shops for himself, handles his own money, cooks and cleans.
Someone who is 18 with a developmental disability is going to continue to learn skills. We would never want them frozen in time with the capacities that they have at that moment. When we impose a guardianship on them at 18, we are essentially having the court freeze that moment in time in terms of their skills. And having decision-making taken away from them means that the opportunity to develop those skills is also taken away.
Well, that would be scary to think that we never had more capacity than we did at 18. I think, again, just like people without disabilities, people with disabilities change over time, they learn things over time so that they can gain capacities, and then as we get older, we probably lose some capacities. But I think to just evaluate a capacity in a broad sense at one particular age and to think it won't change, I think is not accurate and not fair.
Taking away rights doesn't make people safer. Choice and control make people safer.
Choice is fundamental to who we are. When we take choice away from an individual, we are essentially treating that person as less than human.
So I ended up going to a boarding care home, and it was really a bad experience because I learned that you had to go to bed when they told you, when they wanted to put you in the bed, and you had to get up when they were ready to get you up. You had to eat what they cooked or you wouldn't be able to eat at all. It was like being punished for a crime you didn't commit.
One of the problems with guardianship is that when a court comes in and tells an adult with a disability, a young adult with a disability, that they are incapable of making their own choices, that's a very powerful and negative message. And as a result, that person is not given the ability and the opportunity to make choices and to learn from those choices and to become better at making choices.
Choice and control of your life is what promotes safety. Being able to say, I trust this person and I want them to help me, or I don't trust this person and I don't want them to help me, is what helps keep people safe. I have a patient who is very nervous about having a pap smear, and when she said no, we respected that decision and said, okay, here's why it's important, let me explain what it is. I showed her what a speculum is. We practiced getting on the exam table and getting undressed so that she would know what that was about. And when she said, but I'm not going to do this, we respected that. The next appointment, she brought it up. She said, you know what? I'm ready to have this procedure done now. I understand it's important. And the fact that she knew that she was in control is what allowed her to get that pap smear done.
Most families and lawyers and judges impose a conservatorship or guardianship because of a desire to protect an individual. It is incredibly well-meaning. But the legal document doesn't provide that protection. And in fact, one guardian seldom can provide that protection. What studies have shown is that the best protection is actually training in how to make judgments, how to recognize dangerous situations. The empowerment of self-agency so that someone knows how to say no or someone knows how to ask for help. That's what keeps people safe, not a piece of paper.
We hope this video has given you an overview of how guardianships and conservatorships may be problematic for some individuals and some families. The next video will give you more information about supported decision-making, a promising alternative to guardianship. In the final video of this series, we will take you through a step-by-step guide to implementing supported decision-making. All of these videos can be found at www.aclu.org/SDM.